How many we got?
22, 21, because we handled seals early.
For arraignment.
Yeah, for arraignments, and just.
Everyone here for arraignment, you'll be called up, told what your charges are. If you would like an attorney and you can't afford one, a public defender will be appointed to represent you, or you can retain your own attorney or represent yourself if you want to. And the state may make offers to you if you want to resolve your case today. And if you do, your rights are that the rights you have that you'll be waiving if you accept an offer is a right to a jury trial, right to an attorney, right to remain silent, the right to make the state prove its case beyond to the exclusion of every reasonable doubt, the right to testify, the right to call your own witnesses if you want to or have any. These are various rights that you have that you will waive if you enter a plea. And you don't have to enter you can enter a not guilty plea or a no contest plea or guilty. No contest means you're not admitting you did anything wrong, you're not denying it, you just want the court to go ahead and handle it today. We're ready with Jamie Bernard. Is he here? Or she? They did. Chad Brown.
Your Honor, Tim Gibbs on behalf of Mr. Chad Brown. This is 23 CF 2214. Judge, we'd like to enter a plea of not guilty at this time, request 15 days for any pre-arraignment motions, and request trial by jury.
All right, Mr. Brown, you're charged with burglary of a dwelling, armed, aggravated battery on a person 65 years of age or older, vehicle theft, and grand theft. $100 more, but less than $7,500. You public defender's appointed. He's pled you not guilty. It will set you for February 26th. Okay? Thank you.
See you before then.
Is it Adriana Burgess? Was that person notified? It says the public defender. Were they appointed first?
I called her name earlier. I didn't have any response. If we could leave her for the end, Judge.
No bond capias pending first appearance. Michelle Diane Coleman. Okay.
Good afternoon, Your Honor. Tim Gibbs on behalf of Michelle Coleman. This is 23 CF 2261. Judge, at this time, Ms. Coleman would like to enter a not guilty plea and leave this set for pretrial. We'd request 15 days for any pre-arraignment motions and request trial by jury.
All right, Ms. Coleman, you're charged with trespass, a structure, or conveyance, resisting an officer without violence, possession of a weapon or ammo by a convicted felon. Attorney is appointed, public defender. We'll set you for February 26th pretrial, okay? Thank you.
Thank you, Judge. Get an appointment.
Robert Garrett.
Your Honor, Tim Gibbs on behalf of Robert Garrett. This is 23 CF 2311. Judge, we have reached an agreement if I may approach.
All right. This is 23 CF 2311. You are Robert Lee Garrett?
Sir.
Okay. Would you please raise your right hand to be sworn? You swear the testimony you give for his court's the truth, so help you God?
Yes, sir.
Okay. You want to enter a no contest plea. Count 1, possession of a controlled substance, fentanyl, third-degree felony, and possession of paraphernalia, first-degree misdemeanor. So you want to enter a no contest plea to those charges, correct, sir?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Gibbs has done for you on your case? Okay. Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudicated guilty on both counts. You're sentenced to time served, $100 cost of prosecution, $515 court costs, $150 PD fee, due within 180 days of release from incarceration, or it goes to a judgment.
Yeah, Judge, he has a Jackson County child support purge. He's got another, at least, I think, 90 days on that he's got to go to Jackson County for, so that's why we asked 180 days after incarceration.
Okay. So as far as we're concerned, I believe
He'll be transported to Jackson County as soon as they get him.
And then that purge, that'll be in Jackson County. You'll have to explain why you may or may not owe child support. Okay?
Yes, sir.
Good luck to you, sir. Thank you.
That's your copy, just for your records.
Antonio Ray Gavin.
Your Honor, Mr. Gavin is present and approaching. Tim Gibbs on behalf of Antonio Gavin, 23 CF 2267. I believe we've reached an agreement with the state.
All right, Mr. Gavin is charged with possession of a controlled substance without a prescription, a third-degree felony, resisting an officer without violence, a misdemeanor. First degree.
So what do you have? What do I just need you to sign right there for me? So I won't be going into any defenses or anything. Time to approach.
Mr. Gavin, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God. This is 23 CF 2267, State of Florida versus Antonio Gavin. You want to enter a plea to possession of paraphernalia, lesser included offense, so that's a misdemeanor. Is that correct, sir?
Do you want to enter the plea to the paraphernalia charge?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes,
Are you aware of the rights you're waiving by entering this plea?
sir.
Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Gibbs has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. $50 cost of prosecution, $220 court costs, $100 PD fee due within 180 days. Withheld adjudication. Is there any probation or jail time?
No, Your Honor.
No probation or jail time. So get this paid within 180 days. Okay?
Sir.
Matthew Stephen Gray.
Your Honor, Tim Gibbs on behalf of Matthew Gray. This is 23 CF 2291. He's present and approaching. If I can have just one moment, Your Honor.
All right.
Judge, I would like to enter a not guilty plea today. I request 15 days for any pre-arraignment motions, request trial by jury, and leave this set for a pretrial conference.
All right, Mr. Gray, this is 23 CF 2291. You are charged with possession of controlled substance without a prescription and narcotics equipment possession. So we'll set you for February 26th pretrial.
Give me-
Okay. Jaleb Hagens. Hagens. Jaleb Tyrell Odell Hagens. Capias, no bond, Capias, pending first appearance. Javon Terrell Harris.
Judge, with regard to Mr. Harris, I represent him on this case. It'll be a plea of not guilty, request for trial by jury, and 15 days for any pre-arraignment motions.
All right, Mr. Harris, this is 23 CF 2265. You're charged with trafficking in fentanyl, 28 grams or more, possession of marijuana, more than 20 grams. Will set you for February 26th pretrial. Thank you.
Thank you very much, Judge.
Marcus Jamal Harris. You are Marcus Jamal Harris. Good. This is 23 CF 2218, State versus Marcus Jamal Harris, charged with aggravated battery on a law enforcement officer.
Yes, sir.
Is there a offer from the state? No?
Well, the offer is for 10 years DOC consecutive to another sentence I believe he's facing.
Appointed public defender represents you.
As of right now, sir, yes, sir.
And, okay, you have a right to retain an attorney if you want to, or represent yourself.
Yes, sir.
But we'll appoint the public defender. He's going to plead you not guilty, set you for February 26th pretrial, okay?
Yes, sir.
Thank you,
Thank
Judge.
you. Next case, Kenneth Harrison. This is 23 CF 2222 and 23 CF 2223.
That's correct, Judge. It looks like we've been appointed on both of these cases. I have met with Mr. Harrison back earlier in October. I'll enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions, and demand trial by jury.
All right, Mr. Harrison, you're charged with attempted homicide, premeditated, fleeing, attempting to elude police at high speed, reckless driving with a subsequent conviction. So you've been pled not guilty. We'll set you February 26th pretrial.
Thank you,
Okay,
Judge.
thank you. Seth Hillis.
Judge, I met with Mr. Hillis I'm going to enter a plea of not guilty on his behalf and request 15 days for pre-arraignment motions, trial by jury.
All right, this is 23 CF 2240, State versus Seth Hillis. You're charged with possession, controlled substance, and trespassing property not a structure or conveyance. Your attorney is a public defender appointed, and you are pled not guilty. We'll set you for February 26th pretrial.
Thank you, Judge.
I got a question. Is it?
Sir, you're out on bond. Is you see a restriction on his bond about travel? Okay. You just need to make sure it's okay with your bond? Okay.
Is there like somewhere I can get the bondsman's number?
Are you showing a professional bondsman on it, ma'am? He's wanting to go visit his family, and there's no bond restriction that would prevent that. But typically, I tell them to check in with their bondsman. An ROR? Okay, then you don't have a bondsman, so you can go. Just be sure that you're back, okay?
Well, obviously.
Okay.
All right,
You'd be amazed how often I have to explain that.
February?
February
Yes, sir.
26th.
Yeah, just contact my office when you get back, okay? Okay.
Curtis Inglis, or Inglis. Michael Livingston, did we do him this morning? All right, this is 23 CF 2284, State versus Michael Livingston. Okay.
Judge, this is Jay Williams with the Public Defender's Office. I've been appointed to represent Mr. Livingston. I'll enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions, and demand trial by jury.
All right, Mr. Livingston, you're charged with burglary with an assault or battery resisting an officer without violence. Your attorney's pledged you not guilty. We set you for February 26th pretrial. Thank you.
All right, I'll come out and see you again.
Danielle Nicole Manis, 23 CF 2271.
Judge, I originally spoke to her when she was in jail. When the court started calling up my cases, I was looking at the jail list to see if she's still on it. And I do not see her on the jail list.
She got notice to be here.
Judge, when I met with her, she was in jail. That was back on the 12th, and we discussed that she had the case, but I feel relatively confident when...
She said she was released on the 30th of October.
Okay.
They would ask for papers.
No bond capias pending first appearance. Stacy McDonald.
Ms. McDonald is approaching, Judge. Judge, if we can pass Ms. McDonald for just a minute, we've gotten discovery on it, and I'll go over the potential plea offer with her.
Okay. We'll call you back in a few minutes, Ms. McDonald. Spence Phillips.
No, ma'am. Have a seat. Have a seat.
He's in custody.
Just please have a seat. I'll be with you.
We've reached an agreement in this matter, Your Honor.
All right. This is 23 CF 2217, State of Florida versus Spence Joseph Phillips.
If I may approach?
Yes. You are Spence Joseph Phillips.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God? This is 23 CF 2217, State of Florida versus Spence Joseph Phillips. You are entering a no contest plea to introduction of contraband, a third-degree felony, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
I did.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir, I am.
Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir, I am.
Court finds that plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you to credit for time served. What is 5 years? Is he sentenced to credit for time served?
Your Honor, he's serving a 5-year prison sentence under another case number.
Okay.
The state is agreeing to give him credit for that some of that time before his arrest, and so calculating the number of days the state's willing to give him credit for, as of today's date, is the 400 and something days.
Well, this says 5 years DOC concurrent to all other sentences, so he's not getting a. Is he getting a 5-year DOC?
Yes, Your Honor. He is getting a 5-year concurrent DOC sentence with credit for those 456, I think it was,
Okay.
days.
All right, so he's a judge guilty, sentenced to 5 years Department of Corrections, concurrent to all other sentences and cases with credit for time served to 456 days, correct?
Yes, Your Honor.
Because you have a judge guilty CTS. To me, that's a jail sentence. Credit for
Okay.
time served, you know. So you are sentenced to 5 years Department of Corrections, concurrent to all other sentences and cases, credit for having served 456 days, and that is April 18th, 2022 to June 5th, 2023. 414 days plus, and that is from 9/28/23 to 11/9/23, plus 42 days. $415 court costs, $100 cost of prosecution, $150 PD fee, adjudicated guilty. Is that it?
Thank you.
Thank you.
Appreciate it.
Christopher Popple. You are Christopher Roy Popple?
Yes, sir.
All right, this is case 23 CF 2210. You're here for arraignment on, you have 30 counts of obscene possession of obscene material. And is that a second-degree felony?
Your
Miss?
Honor, those are possession of child pornography. They're a third-degree felony. There's also promotion of sexual performance by a child, which is a second-degree felony, and unlawful use of a two-way device, which is a third-degree felony. It's the exposure of 170 years.
170 years?
Yes, sir, with a minimum guideline if convicted of 11 years.
And a minimum guideline sentence of 11 years. So that is what you are charged with. I'm going to appoint the public defender to represent you.
Your Honor, we'll enter a not guilty plea.
Okay.
Request trial by jury.
Set you for February 26 pretrial.
Thank you, Your Honor.
Kevion Seals. We did, okay. Keith Marcel Shanklin.
Mr. Shanklin.
Hello there, Mr. Shanklin. So, Your Honor, during lunch, I received a letter from Mr. Shanklin, and in it, he made some allegations which would basically amount to a conflict of interest for the public defender's office to represent him based on allegations against Charles Hall. So I can either move at this time, orally move to be removed, or just file a motion It's,
Well, go ahead and orally remove, and then I'll just point regional conflict counsel.
and she is present. Jennifer Flowers is going to be your attorney. 'Cause you-
All right, you're being
I'm out
appointed
seeing-
regional conflict counsel. They're a whole different, defense attorneys, different from the public defenders, okay? Ms. Flowers is right over here.
I'll be at the next week, and if the public defender would just follow up with a written order, we'll always do.
Yeah, send me a written order, please, okay? And plead him not guilty. Oh, you're charged with petty theft, third or subsequent conviction, and use of an anti-shoplifting control device. So the court's going to plead you not guilty, set you for February 26th, point to regional conflict counsel. Ms. Flowers will be up to see you, okay?
Yes, sir. I'm gonna ask if I could get a signature bond on that one. I have a signature bond on the other one. The report, sir. I'm just trying to be home with my family for
I
the
got you.
holiday. Been
What is the
in jail
state?
40 days.
You've been in 40 days?
Yes, sir.
Is there any offer?
It's state prison.
Oh, okay. We can
Nah.
address your bond at a later date.
We'll have to set a formal bond hearing.
Yes, sir.
Okay, so the state has a chance to review your record and see what they say.
Yes, sir.
Okay? Thank you.
All right, thank you, sir.
Kenneth Kyle Stoffel. (23 CF 2213).
Your Honor, we've reached an agreement in this matter, if I may approach.
All right. You are Kenneth Kyle Stoffel? All right, this is 23 CF 2213, State of Florida versus Kenneth Kyle Stoffel. Would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God. Okay, you want to enter a no contest plea to the charge of possession of less than 20 grams of cannabis of misdemeanor, first degree, and possession of drug paraphernalia, first degree misdemeanor, and the state's going to drop the possession of a controlled substance felony
That's correct,
charge.
Your Honor.
So you want to enter a no contest plea to 2 misdemeanors, correct? Okay. Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudication is withheld on both counts. $270 court costs, $50 cost of prosecution, $50 PD fee, and $50 app fee. No probation.
Your Honor, I think there was an adjudication on the paraphernalia, just not on the possession.
Yes, that's correct.
Well, I just,
So
all I have is,
I may have written that down wrong, Your Honor, but it was to be a plea, an adjudication on the paraphernalia, but not on the cannabis. And I did withhold.
so adjudicated guilty on the cannabis, correct?
No, Your Honor, adjudication withheld on the cannabis, adjudication of guilt on the paraphernalia. That way it doesn't affect his license. This is a copy for you to keep.
Count 2, withheld adjudication. Count 3, adjudicated guilty.
Yes, sir.
Okay. All right. No probation, right?
Yes, Your Honor, that's
Okay.
correct.
Stay away from these drugs that cause you all kind of problems. Stephen Bradley Ziglar.
But she said she's trying to.
All right, you are Stephen Bradley Ziglar.
Yes, sir.
This is 23 CF 2263. You're charged with possession of more than 20 grams of marijuana.
Your Honor, we've reached an agreement in this matter, if I may approach.
Okay. Would you please raise your right hand, sir, to be sworn? You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
All right. Did you read and sign this plea and sentencing agreement form? You aware of the rights you're waiving by entering this plea?
Sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. And your plea was to a misdemeanor, lesser included offense of possession of marijuana under 20 grams. You understand that?
Yes, sir.
Okay. And so the court is going to adjudicate you guilty, $270 court costs, $50 cost of prosecution, $100 PD fee. No probation, correct?
That's correct, Your
Okay.
Honor.
Thank you.
Thank you.
Who else? Who's next? We have anyone else out there for arraignment?
Judge, we had Mr. Jesperson on the docket originally, but I filed in writing on him, and he's already been set. I don't recall off the top of my head if it's the 27th or the February 26th.
Who is it?
Jesperson, that's the homicide case, Ms. Slanker.
Oh, okay, yeah. All right, so
Sandler has, rather.
what do we have left?
We have a sentencing hearing on Ms. Moffett. I believe my witness is present.
What about Stacey McDonald?
Oh, we have Stacy McDonald. We had passed it. That's going to wind up being a plea, Judge. Ms. McDonald?
23 CF 2212, Stacy McDonald.
Yes, sir. Judge, this is Stacy McDonald. The state has made an offer for time served with an adjudication on it.
Okay. Ms. McDonald, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God? All right, this is 23 CF 2212, State of Florida versus Stacy McDonald. You want to enter a no contest plea to charge of possession of a controlled substance, a third-degree felony, and possession of less than 20 grams of marijuana, a first-degree misdemeanor, correct? You got to say out loud, we're recorded.
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Or where the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case?
Yes.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty on both counts. Sentence you to time served, $100 cost of prosecution, $515 court costs, $50 PD app fee, $100 PD fee. Okay?
Thank you, Judge.
Thank you. The motion to continue on which case? Oh. We'll do it February 26th. Yes. All right, two we got left.
Judge, I just have that sentencing that was set for 2 o'clock.
Did I get a PSI? Did I order a PSI?
No, Judge, I don't believe you did. It's a violation of probation. She entered a admission.
What's the case number?
There are 2 cases, Judge, and it's going to be 19 CF 3507 and 20 CF 562.
20 CF 562?
562, Judge.
What's her name, Moffett?
Her name is Crystal Moffett, Judge, and she has not yet been brought out, but I expect she'll be out in just a minute.
And this is a plea to the bench.
Yeah, she's already, in fact, made the plea. You just wanted to pass the...
This is a plea to the bench. May I
Sentencing
approach her
hearing.
this question?
She's on the other end of the hall.
Oh, okay. Well, do you have others?
I have Mr. Gabriel right here. I think that's probably the most important.
Okay.
Moffett is entering a plea or has entered a plea?
My recollection, Judge, is that she had entered a plea. The state just wanted to put off sentencing until they could have their witnesses available. We had Ms. Moffett's mother-in-law, who was a witness on our side, present in court last time, and she came back down so that she could be present today. She's from Tennessee.
Okay.
All right. Judge, Ms. Moffett's with us at this point. Judge, Ms. Moffett scores on the score sheet that I was handed 36.9, but I'm showing an additional 12 points, whereas this violation, so this is either an old score sheet or it's scored as an additional felony when we're not before the court with an additional felony. Long and the short is the state was asking for a rather substantial amount of time on it. Ms. Moffett admitted having left the probation. She was having trouble maintaining sobriety here, was afraid she was going to violate. She went to Tennessee. The state pointed out last time that she had a dependency case pending down here, or pointed out to me. I've spoken with her and her mother-in-law about that. The child in that case, I believe, is the grandchild.
My grandchild, yes, sir.
And the case was sent up to Tennessee. When Tennessee started their case, our case down here, Judge Frederihovich was the judge on it, dismissed the delinquency or dependency case down here. Tennessee subsequently dismissed the dependency case up there, largely because she's been clean.
Mr. Williams, do you have any evidence of that, that the Tennessee case has been dismissed?
I'm going to have her and the mother-in-law testify about it. If you,
Go ahead.
this is in the nature, I'm sorry, of my opening statement. So basically, Judge, everything that we wanted to accomplish by putting her on probation has been accomplished. She's clean. She's not used. She's not committed any additional crimes. Did she violate her probation? Yes, she did. But it's not a situation where she should be sent to prison. We're going to ask for time served on it, ask that the court, we're going to elicit some testimony about her circumstances. We hope that the court will, well, we may not even need a downward departure on this. Let me look again. Yeah, I'm still showing, even with the 12 points, this as being 36.9, so a downward departure would not be necessary. And again, this is based on the score sheet I received in discovery on the VOP.
And Mr. Williams, the reason the 12 points is there is because this is their second violation.
Okay, so it's 6 and 6 and not a felony? Okay.
Correct.
All right, then that would be correct, Judge. But it's still less than 44. Judge, let me call the mother-in-law first. What's the last name?
Rhonda Baez.
Ms. Baez, Rhonda Baez? Okay. And Judge, actually, I'm looking at a letter from the defendant. I had intended for that to be forwarded on to the state and to yourself, and it doesn't look like it was. But I can have her read that letter into the record today as part of her testimony.
All right, would you please raise your right hand and be sworn. You swear the testimony you give before this court is the truth, so help you God.
So help me God.
Okay, go ahead.
Thank you. Ma'am, would you state your name for the record?
Rhonda Baez.
And Ms. Baez, do you know Crystal Moffett?
Yes, sir, I do.
And how is it that you know her?
Crystal came into my life approximately 4.5 years ago. And would you like for me to just kind of give you a synopsis?
What's the relationship between her and your family?
She is my granddaughter's mother. Her and my son have been in a relationship for 5 years.
And where were you living when did she come up to live with you at some point?
She came to live with me about 5 years ago, 4.5, 5 years ago, here in Crestview. I was out of town. I came back. Things at first seemed fine, but then it really went downhill. And after I realized that Crystal was doing drugs that should not be, and bringing them in my home, I tried to get them removed, found out it was going to cost so much through the courts. So I decided to sell my house and move to Tennessee.
And when you say get them removed, who are you referring to?
My son and Miss Moffett.
All righty. And so when you moved, where did you move to?
I moved to Dunlap, Tennessee. It's about an hour north of Chattanooga.
All righty. And did you stay in contact with Ms. Moffett?
Not for a little while. Shortly after I sold the home and left, they did not know where I'd moved. Things were that bad.
Yes, ma'am.
So, but I'm still my son's mother.
Yes, ma'am.
And Crystal found out she was pregnant. They were homeless. I left them homeless. Broke my heart, but I could not bring that back into my home.
Yes, ma'am.
Crystal went through her doctor. When she realized that she could carry this child, she has lost many children and had trouble with conceiving.
You mean via miscarriage?
Via miscarriages, yes, sir. I just happened to see it in her medical records when I was helping with So Crystal went to her doctor and told her doctor that she was using meth. Her doctor informed her not to come directly off the meth, that she would help her wean her off the meth, which she did. And when she was admitted to the hospital as a high risk, she was clean of all drugs.
Now, when this was taking place, was this taking place in Tennessee or down here?
It was taking place here in the state of Florida.
Okay.
Either in Crestview and in Pensacola, because Pensacola is where the baby was born.
Okay. All right. So how did things progress after that? With Crystal, I brought my motor. I felt confident enough with her being sober when she went into the hospital, and I was able to look at her medical records with her to verify it. I mean, so the Child Protective Services came in, which that's another long story, but it should have never been. They should have never been called in. The medication in that child's system was the medication that they gave to Crystal while she was in labor. When you say they, you mean
the
medical?
Hospital, the medical staff.
Okay.
And which opened the system. Well, I brought my motor home and my car down here so that she would have a place for the baby to live that was clean and safe, and a way to be able to get the child to and from
the hospital. During her labor, at the very end of her labor, her placenta separated from her uterus, and the child was born with a 1.5 APGAR score, which basically means she was barely leaving. And so there was a lot of medical treatment for the child. Crystal made sure that that baby got to everything. I was behind Crystal. I was back and forth between Tennessee to make sure that things were good in the home. Child Protective Services, she passed everything, all drug testing. And over time, Crystal has gained my trust. She had her setback, and when she left to go and showed up at my house, I was not happy.
Your house in Tennessee?
In Tennessee, but she knew that she had to get her baby somewhere safe. And all she knew to do was come to Mama. No, not her biological mama, but I'm the mama she's got right now. And it was during the COVID, at the end of the COVID and everything. And so Crystal has worked hard getting her child set up into the Tennessee system so that she can get the proper care, and got her into all the therapies and everything that she needs to do. Crystal has been sober. That one instance that she had that I'm aware of, she was sober for 1.5 years prior to that, and she has been sober ever since.
And how long would that be that she's been sober since then?
With the one instance, I would say that it's in the neighborhood of 3 years, maybe a little over 3 years, because the baby, she really didn't think she was going to carry the baby, and she was on the verge of being suicidal, and the baby kicked, and that she realized that maybe there is hope, and that's when she went to the doctor and asked.
Now, that
help.
incident that you're referring to, was that while she was pregnant?
That's correct.
Okay.
I believe she was around her 4th month.
All right, and so since the baby's birth, she's not been using?
No, sir.
Where has she been living?
She's been living with me. I have a cabin in the middle of the woods on the top of a mountain in Tennessee.
And so are you seeing her every day?
I see her every day. She is a vital part of the whole community. She drives for the Amish to take them on their errands, and she has one client that she takes to and from work every single day, and there's a letter in the folder there from Priscilla. My son is working for the Amish as well, and so I go into town. Our little community is like, how's Crystal? Is Crystal? And I mean, they all love her. They miss her, and she has. I think that for the first time in her adult life, she has kind of netted herself a little family, and it's peaceful, and she's happy there.
Have you seen any evidence of any sort of criminal activity?
Not at all.
Is she a good mother?
Oh my gosh. I would hate to say, but she's probably a better mother than I was. But, you know, I had 3 toddlers. She has 1, so she has a little more patience. But her little girl, even though she has cerebral palsy and has the difficulties on her left side, God has really blessed us that cognitively, she is very smart. She was just tested and tested on the kindergarten level.
Was the cerebral palsy related to any sort of
Drug
medical issue, or was it related to drug issues?
It was related. Crystal's placenta was high and in the frontal. After 36 hours of labor, they decided to have her stand up to see if gravity would help the baby to drop, and when they stood her up, her placenta separated from the uterus.
And of course that stopped.
Which caused hemorrhaging, caused the baby to be without oxygen and blood for several minutes. I do not know exactly how long.
Now, I may be asking questions that the judge already knows the answer, doesn't need to hear, but is the placenta the interface between the baby and the mother's circulatory system, including oxygen, waste removal, things of that nature?
Yes, sir.
All right.
That's
And
the
so
lifeline.
when you have the placenta separate from the wall of the uterus, is that child still getting the mother's oxygenated blood?
No.
In fact, does that typically set up massive bleeding inside the mother? Because
Absolutely.
I would object, Your Honor, as to no foundation. This person is not an expert to testify as to
Yes,
medical.
I'm not calling for a medical opinion. I'm calling for.
And it's irrelevant. We're here on a violation of probation for 2 drug charges.
Judge, one of the issues that the state previously raised was implying that the baby's cerebral palsy was as a result of the mother's drug use.
I have
This
raised
goes
no
to the
issues in this hearing, Your Honor. There is no issues raised from the state.
not in this hearing, but in conversations and documents that the state provided. I'm anticipating, and so I'm trying to go ahead and shut it down while I've got this witness on the stand. I'll try to shorten it. Ma'am, is there any indication that the injury suffered by this child or as a result of any drug use on the part of the mother?
None
Objection,
whatsoever.
not hearsay and speculation.
Is there currently a
It's-
lawsuit?
Sir, if you look in your
An
record,
objection as to relevance.
All right. I've made my ruling. Sustained.
All right, ma'am, with does Crystal now have a community to return to?
absolutely, yes, ma'am. Yes, sir, she does.
And again, have you noticed her involvement with any sort of illegality or controlled substances or anything of that nature?
None, and I would know. I've not only I was a correctional officer, I've gone through training, I've gone through my son's getting sober and living and learning a lot from my sons, working in Santa Rosa County Jail. I learned a lot, so I do know, have some knowledge of what signs and things to look for.
And where were you a correctional officer?
Objection as to relevance.
Here in the state of Florida.
It goes to her ability to recognize signs and indications of drug use.
Okay. Don't shout out an answer when you know someone's made an objection.
I'm sorry.
If you're a correctional officer, you know better than that.
Ma'am, where were you a correctional officer?
I was at Santa Rosa County
Okay.
and at Century, started out at Century Correctional Facility,
And how long were you a CO?
6 years.
And during the course of being a CO, have you seen people that were under the influence of drugs?
Yes, sir.
Are you, in fact, trained to recognize if somebody's been using drugs, say, gotten them into the jail or something of that nature?
Yes, sir.
Okay. Ma'am, is there anything else that you feel like the judge needs to know?
We miss Crystal. We would like to see her come home as soon as it's allowed. Crystal has worked very hard to change her life around. It's not often that you take someone from the streets that has lived the life that Crystal has lived, that has found something that is more important to them than their next fix.
And ma'am, how many times have you had to drive down from Tennessee to Northwest Florida for Crystal's current case?
Objection as to relevance.
Thank you very much.
You're welcome, sir.
Good afternoon, ma'am.
Yes, ma'am.
Miss Moffett's lived with you for how long?
She lived with me during the time that she got in trouble. She had been there for, I think, maybe a year and a half, maybe 2 years.
Okay, so you're aware that she violated her probation with a failed drug test, right?
Yes, I am.
And you're also aware that she failed to complete her drug evaluation and treatment that she was ordered by the court to do, right?
Yes, I am.
Are you aware that a warrant was issued for her arrest for absconding her probation back in December of 2021?
Yes, I am.
And she was in absconding status and could not be found for a year and 9 months until she was just recently arrested. Are you aware of that?
Yes, I am.
And she was with you the entire time?
Yes, she was.
Okay. So she was transported from the Bruton, Alabama County Jail.
Yes, sir.
Escambia County. Why was she there?
That was something from before I knew her. I believe it had something to do with the drugs as well, but I do not know the severity of it.
Okay. So you're very up to speed on this case, but not the Bruton, Alabama case?
No, she was. I did not know her at that time. That was about, I think, 5 or 6 years ago.
And she was arrested in Tennessee, correct?
Yes.
And she has had 3 prior Child Protective Service inquiries in Tennessee alone, correct?
No.
And are you aware that she admitted to smoking methamphetamine during her pregnancy of the child?
Yes, but early in her pregnancy.
I don't have any other questions, Your Honor.
Ma'am, redirect, Judge. Did she undergo any sort of substance abuse treatment or evaluations when she was there in Tennessee, including through Tennessee Protective Services?
No, when the Child Protective Services showed up at our house, she passed the drug test. She had no drugs in her system, nor myself, and which I've never used. But they were called to my house from Florida for a wellness check. It was not a case that was opened through Tennessee because of anything that had gone on. It was a wellness check that Florida had called Tennessee, and Sergeant Allen came in with the family of services, and I believe it was Rachel, or what was her name, but they came in and I allowed them to search my home. They drug tested us, and nothing was found. There was no drugs. The baby was well taken care of, had a safe environment, was well fed, and so they did a follow-up to they came and checked on Crystal, I think 2 or 3 more times, just to make sure that things were going okay, and that was it.
Were there, during those 3 or 4 other visits, were there drug tests done there in any of those as well?
Yes, they did the drug testing, and she passed all drug testing.
All right. And so she was picked up in Tennessee and then taken to Bruton and had some legal issues there?
That's correct.
And then from Bruton, she was brought back here?
That's correct.
And you're just not familiar with the Bruton situation because that was before?
That's correct. I do know it had something to do with a drug, but that's as far as I know.
But you do know it wasn't that she went to Bruton and committed a new crime?
That's correct.
Okay. I don't have anything further, Judge.
Thank you. Step down. Thank you.
Thank you, sir.
All right, Judge, at this time I'll call Ms. Moffett. Okay, yeah, you can go ahead. You need to be over here. Yeah. Yeah, you've got a mic here. So.
Is she under oath?
No, Judge, I don't believe you have placed her under oath
Would
yet.
you please raise your right hand to be sworn? You swear the testimony you give before this court, the truth, so help you God.
Yes, sir.
Thank you.
All right. Please state your name for the record.
It's Crystal Moffett.
All right. Ms. Moffett, was there a statement you wanted to read to the court?
Yes, sir. Your Honor, I humbly come before you today and I ask for mercy. Mercy because 2 years ago, I made a bad choice. I had been clean for over a year, having my daughter and learning to be the mother to a special needs child. You see, my daughter had a birth injury that resulted in her now being diagnosed with cerebral palsy. One bad decision led me to a short relapse, but also revealed the truth that I was struggling to stay clean while living in the same environment I'd always been in. I needed a complete change in my life. The only thing that mattered to me at that point was the safety and well-being of my daughter. So I ran to Tennessee, and the safety and support I knew would be offered to me by my daughter's grandmother. I knew that I would have to come back and face what I had done, but there never seemed to be the right time, and if I'm being honest, I was scared. The past 78 days have been the hardest days of my life until now. I've never missed a single doctor's appointment or therapy session. I've never had to rely on anyone else to make sure my daughter does her daily exercises, making sure she doesn't fall any further behind on her milestones. I am truly blessed to have a dependable support system around us, but the cumulative knowledge that I have about my child and her medical needs cannot be taught. Studies show that the best outcome for disabled children is always through early intervention therapies. In closing, Your Honor, I ask for leniency. I'm not the person that I was 3.5 years ago. My responsibilities and priorities have drastically changed. I humbly ask for mercy not only for myself, but for my daughter. Thank you, Your Honor.
Now, ma'am, is there a pending lawsuit with regard to those injuries?
Yes, sir.
Who's the defendant in that suit?
Myself and my daughter. For,
y'all are the plaintiffs. Who's
I'm
the
sorry.
defendant?
Sacred Heart Hospital.
Okay. Do you have an attorney representing you on that?
Yes, Brooke Charlene with Morgan & Morgan has been my lawyer for the past 2.5 years.
All right, thank you.
Any questions, Ms.?
Yes, Your Honor. Ms. Moffett is Sacred Heart Hospital. They're the ones who you're involved with the lawsuit.
Yes, sir.
Are they aware that during your entire pregnancy you have admitted to smoking methamphetamine?
I went to my doctor. My doctor's
It's
there.
just a yes or no. Are they aware that you
They were.
have admitted to
Yes,
smoking
ma'am.
methamphetamine?
Yes, ma'am. They're aware.
And Department of Children and Families, Child Protective Services, they actually have, they raided your home and found drug paraphernalia in your home. And
Not to my knowledge, no, ma'am.
okay. Are you aware that the state of Florida in this county granted an order to take your child into custody?
Ma'am.
You're not aware of that?
No, ma'am.
They did so in 2023 in case number 22DP63. So you're not aware of that?
No, ma'am, not at all. The only thing that I was aware of was that they came to the house in Tennessee, and I swapped over to Tennessee, and Tennessee cleared me.
And no one could find your child, that's why during the shelter hearing, the child was ordered to take into
the
custody.
question is things facts not in evidence. No one has testified as to that rationale.
Stay.
Just asking her about it on cross-examination.
Well, you stated it as fact, though, and it's not established yet.
I just asked her if it was true, that if she knew that her child had been ordered by the court to be taken by a child.
I said sustain.
And you absconded from your probation for 1 year and 9 months, correct?
Yes, ma'am, I did.
And you never checked in with probation during that time at all?
During that time, no, ma'am.
And you actually, you fled once you gave a drug test to your probation officer, and in the office, it was presumptive positive. So you had absconded once you knew you were going to fail the drug test.
I knew going in that I was going to fail the drug test. I had had a short relapse, and all I could think was that I needed to get my daughter somewhere safe where I knew she would be well taken care of if and when I did go back to jail.
And you knew this was your second violation of probation, so you figured you would be going back to jail, right? And that's
Yes,
why
ma'am,
you
I did.
fled? I don't have any other questions, Judge.
Okay, thank you. Next witness.
No further testimony, Judge.
All right. What is the state asking for?
Judge, following the recommendation of probation recommended incarceration, revoke and terminate, the state was requesting an adjudication of guilt, revoke and terminate with 6 months county jail. There is a cost of transportation of $170.21, and then, of course, a $100 cost of prosecution. I thought that was a fair offer, Your Honor, considering she absconded for so long. She just up and left, didn't notify anyone, and this is her second violation of probation. And she has prior credit, so the state's offer included credit only for the jail time she served since she's been in custody, since she was arrested on the capias.
So she is, what was the $170.20?
There's a cost of transportation to the sheriff's office. When
Oh.
the capias was issued just recently at the end of September, they transported her from the Escambia County Jail, and so the sheriff's office has filed, there's a order in benchmark.
Was she in jail, Escambia County Jail, on this violation of
She was taken from, apparently from Tennessee to the county jail to handle some matters over there in Escambia County.
I think she means Escambia County, Alabama.
Right, Bruton, Escambia County in Alabama.
Oh, that's the Bruton.
Yes, sir.
And what happened with that?
It's still, I still have to go to court on it, Your Honor. I'm supposed to be at court on the 16th for my arraignment of this month.
What's that charge?
It's a possession charge from 6 years ago.
And what are you finished, Miss?
Yes, Your Honor.
And you're asking for 6 months county jail?
Yes, sir. Credit for time served since her date of arrest, which is, I have as September 28th, 2023.
And what are you asking for?
Judge, what she would prefer to do, and she's even spoken to me about being back on supervision so that she can go back to Tennessee. And apparently they've had some contact with Tennessee, and Tennessee is ready to accept her back. And of course, she's got family. She's got the child there. She's got the mother-in-law there. She's been living there now for several years. So that's what she's asking for, Judge. An alternative would be essentially give her time served. Everything that we wanted to accomplish by putting her on supervision, we've accomplished. She's not using anymore. She's a productive member of society. She transports Amish people around. That's how she makes her living. She's a member of a community. They like her. They miss her. They ask about her. She has done everything that we hoped to accomplish, frankly, more than I would have hoped to accomplish when she was initially placed on probation. Now, I didn't have her originally, so I can't say that that's what I was thinking back then. But in a similar circumstance, that would actually be more than I would actually think likely to happen.
So, Ms. Glisson, you're asking for straight jail time, no probation?
That's correct, Your Honor. And that's also what the probation officer had recommended in the affidavit.
She been adjudicated?
Judge, she says she doesn't think so. I would be surprised if she had not. But it should be immediately available on the clerk's website. It was withheld?
For the last violation as well.
Yes, the one from 2020 says withheld.
Okay.
Is there a hold on her from Bruton?
So she advises me that she bonded out on that charge. So there would not be a hold on her. Sounds like she bonded out in Bruton and then they picked her up and brought her.
All right. Court adjudicates you guilty, sentence you to time served, $170.20 cost of transportation, $100 cost of prosecution. Continue doing a good job raising that daughter, I guess, and stay away from drugs. You're going to get messed up if you don't.
Thank you very much, Judge.
Thank you, Your Honor.
Outstanding DOP monies to collection, Judge?
Yes. Mr. Stewart, Miss...
Judge, I have an add-on that we can take. Mr. Alvin Williams.
Williams?
Yes, Your Honor.
Oh, he's... okay.
Your Honor, for the record, Brad Stewart, on behalf of Alvin Williams, Jr. Judge, this is 23 CF 472. Mr. Williams is present before the court. If I may pause for a moment while he signs a previously reviewed written plea agreement. Your Honor, at this time, Mr. Williams is prepared to tender a plea of no contest with the understanding that he'll be adjudicated guilty, placed in the Department of Corrections for a period of 30 months, credit all time served. That will run since August 22nd, 2023. The sentence shall run concurrent with a Walton County sentence in the Walton County case number 23 CF 117. Court costs as applied within 90 days after release. There is a 1-year statutory driver's license suspension. Count 2, the DWLSR misdemeanor shall be adjudication credit time served. I would request that the court reflect in the clerk's minutes that he may be housed in a local facility. May I approach?
You are Alvin Latrell Williams, Jr.?
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes, sir.
This is 23 CF 472, State of Florida versus Alvin Latrell Williams, Jr. You want to enter a no contest plea to the charge of is it fleeing and attempting to elude?
Yes, sir. Count 2 is...
second-degree felony.
Yes, sir. Count 2 is DWLSR.
And driving license suspended, revoked, a second offense, a first-degree misdemeanor, correct?
Sir.
Did you read and sign this plea and sentencing agreement form? You aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Stewart's done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 1, judge guilty, sentenced to 30 months Department of Corrections with credit for time served since August 22nd, 2023. Sentence shall run concurrent with the Walton County sentence in 23 CF 117. 615 court costs payable within 90 days after release, then to civil lien.
It's a 1-year driver's license revocation.
A 1-year driver's license revocation. Statutory driver's license suspension. In count 2, judge guilty, sentenced to credit for time served. And local facility, I have zero control over what the Department of Corrections, where they house you. So, you know, if I say I recommend local facility, they'd probably send you to Miami or somewhere. You know?
It is what it is, Your Honor.
You know, I used to tell my clients, if you want to be in prison up here, ask to be sent to Dade. If you want to be in Dade, ask them to send you to prison up here. I don't know if it worked, but you know, that's, I don't know.
Yes, sir.
It just seemed like that's what would happen. I have no idea how they, but I think they do try to get you close to home. So, especially if it's non-violent like this. So,
There's an attached score sheet as well, Your Honor.
yeah. How much time have you got served already?
I believe we're approaching 3.5 months.
3.5 months.
Yes, sir.
Probably won't be down here very much at all with the non-violent type. I don't know what you got going in Walton County, but probably won't be down there very long at all. Or if you do get with this kind of sentence, you're probably going to be in a very minimum security facility, working on the road or whatever. So good luck to you. Okay.
Yes, sir.
Okay.
Thank you, Your Honor.
Thank you.
You good? You good?
And
Your
what
Honor.
are we doing
I believe we're going to have a plea on Mr. Roca, Judge. If I could just have a few minutes to, I have a writ plea drafted, and
okay.
I just need to show it to him and confirm it with him.
Well, we want to,
Reserve restitution for other.
Gabriel? Okay.
Victim compensation fund and all of that, medical records, medical, I don't know.
All right, this is State of Florida versus Anthony Michael Gabriel, 21 CF 2022, 21 CF 1861, and 20 CF 2880. He's here for sentencing. He was found guilty by a jury of burglary of a dwelling while armed with a firearm, possession of a firearm by a convicted felon, and fleeing, attempting to elude violation of probation, that he was on probation for fleeing, attempting to elude a law enforcement officer reliance and siren.
May I approach with a score sheet, Your Honor?
Yeah, well, yeah, I've got one. Okay. All right. All right, go ahead.
Your Honor, Leah Glisson for the state.
Jennifer Flowers on behalf of Mr. Gabriel.
Okay.
Your Honor, the state filed a sentencing memorandum that outlined what the state was asking for and the reasons why. There are some mandatory things that we need to address on the record. The first, if the court doesn't mind, I will address count 1 of 22 CF 2022, dealing with the count of burglary of a dwelling while armed with a firearm. The jury found the defendant guilty of that charge. They also found the defendant actually did possess a functional firearm. So under the 1020 life statute, that requires a minimum mandatory sentence of 10 years imprisonment for the firearm possession alone for count 1. And count 1 is a punishable by life in prison felony. So what we look at next is the issue of the defendant being count 1, for count 1, a prison releasee reoffender. And for that, according to section 775.0829A1P, PRR means someone who commits or attempts to commit armed burglary within 3 years after being released from a state correctional facility operated by the Department of Corrections, within 3 years after being released from a correctional institution of another state, or any other foreign jurisdiction following incarceration for an offense which is a sentence eligible for punishable by 1 or more years in this state. What that means, Judge, is that this defendant is eligible for PRR because we know that Mr. Gabriel, according to his pen pack, which I'm going to introduce into evidence, he was released from prison within 3 years of committing an enumerated offense. And the courts have laid out in statute, in the PRR statute, the charges that are enumerated offenses. Armed burglary is an enumerated offense. So because this defendant was found guilty of committing an armed burglary within 3 years of his release from a prison facility, that the court should classify Mr. Gabriel to be a prison releasee reoffender. And if I may approach, Your Honor, I do have the defendant's certified pen pack that indicates his release from prison being June 8th of 2020 for possession of a controlled substance. He was also released from prison March 13th of 2020 for smuggling contraband into a prison facility. And I've provided this to Ms. Flowers as well, and I may approach and enter this into evidence of State's Exhibit A.
Any objection?
Objection.
All right, entered as State's Exhibit A.
And Your Honor, also to qualify under the PRR statute, one of the requirements is for the state to show that the defendant had not been given any type of immunity or clemency for that charge. And I also have the certified clemency letter certifying that Anthony Gabriel had not been given clemency, his rights had not been restored, and there's no overturned convictions for what he was released for prison for, and that is State's Exhibit B, also previously provided to defense. May I enter it into evidence?
All right, this is the clemency letter. It's entered as State's Exhibit B.
That's right.
Certified.
And additionally, Your Honor, there's a requirement that the defendant be put on notice that he was eligible for a prison releasee reoffender status. In addition to the state putting the defendant on notice at pretrial and docket day for the past few pretrial and docket days, the defendant was personally served at the jail by the state attorney's investigator with a notice of intention to seek PRR status, and the defendant's attorney was also sent notice as well. And Ms. Flowers, do you acknowledge receiving notice of that as well?
Yes.
And prior to the trial, Mr. Gabriel, he also admitted on the record that he had received notice and he was well aware that he was eligible for PRR sentencing. When we're looking at PRR for count 1, Your Honor, the state attorney has to just establish beyond a preponderance of the evidence that the defendant is in fact a prison releasee reoffender as defined in the statute. And if the court determines the defendant is a prison releasee reoffender, the defendant must be sentenced on a crime that's punishable by life, as count 1 is here. The defendant must be sentenced by a term of imprisonment for life. And as a prison releasee reoffender, the defendant must serve 100% of his life sentence and is not eligible for any form of early release, and that is pursuant to 775.082. And at this time, I would ask the court, considering the evidence that's been presented, to find that the state has found beyond a preponderance of the evidence that the defendant is in fact a prison releasee reoffender for purposes of count 1 and 21 CF 2022.
Your Honor, we have no evidence and do not object to the findings.
I believe Mr. Gabriel was notified repeatedly that the state was going to be seeking prison release reoffender, and state has established the criteria for that condition, so the court designates Mr. Gabriel as a prison release reoffender.
Thank you, Your Honor. And based on that designation, for count 1, the defendants must be sentenced to a minimum mandatory sentence of 10 years imprisonment pursuant to the special findings the jury made for the 1020 life statute with the firearm. And he also must be sentenced to a minimum mandatory sentence of life imprisonment pursuant to the PRR statute for count 1. As a result, the case law tells us, Your Honor, that the defendant, it is permissible for the court to sentence the defendant to life in prison for count 1, minimum mandatory, to run concurrent with the 10-year minimum mandatory for the 1020 life gun charge. So that is the state's recommendation for count 1. Going on to count 2, which is possession of a firearm by a convicted felon, the jury also found the defendant guilty of that count in a bifurcated trial. The jury found special findings that the defendant did in fact possess a firearm, and it was an actual functioning firearm, which satisfied the 1020 life statute. That requires a minimum mandatory sentence of 3 years imprisonment due to the possession of a firearm qualifying as an enumerated offense. And Your Honor, there's case law that allows the minimum mandatory to run consecutive to count 1, but for sentencing purposes here today for count 2, the state's recommendation, because count 1 and 2 arose from the same criminal episodes, they were both charged under the 1020 life statute. The court is permitted to run the minimum mandatory sentence for count 2 concurrent to the minimum mandatory sentence in count 1. So the state's recommendation for count 2, which is punishable by up to 15 years in prison, is an adjudication of guilt, 15 years Department of Corrections with a 3-year minimum mandatory pursuant to the 1020 life statute, and have the entire sentence of count 2 to run concurrent with count 1 to simplify the sentence. There's also standard court costs and costs of prosecution. And finally, Your Honor, for the violation of probation, Your Honor found him guilty, or you found him to be in violation of probation. We heard testimony during the trial. The defendant was placed on 3 years of felony probation for fleeing or attempting to elude a law enforcement officer on June 17th of 2021. And the charge arose after Okaloosa County Sheriff's Office conducted a traffic stop on a vehicle the defendant was driving. Once the deputy approached the vehicle, the defendant sped away, which slung mud and debris onto the deputy. And while the defendant fled through some of the busiest roads in Crestview, fleeing from law enforcement, he failed to stop at a red light, as well as 3 stop signs while traveling at a high rate of speed. And the only reason Mr. Gabriel's vehicle was successfully stopped was because Okaloosa County Sheriff's Office deployed spike strips. It should also be noted that during the fleeing and eluding, the defendant, his driver's license had been suspended or revoked, and he admitted to such. The violation of probation of fleeing and eluding a law enforcement agency when he was put on probation, that charge is punishable by up to 15 years in prison. And once the defendant violated his probation, the probation officers originally labeled him to be a violent felony offender of special concern. And there's a few things that the state has to prove in order for the court. It's called a danger hearing, and what we have to do is show that the defendant was a danger to the community. And the court will either determine, yes, he is a danger to the community, and there's certain things that we look at, or no, he's not. And I would just take a minute and I'll present the reasons that I think that he is a danger to the community. The state of Florida thinks he's a danger to the community. And the statute tells us that if the court does find the defendant is a danger to the community, the statute reads the court shall revoke his probation and sentence the defendant up to the maximum statutory as allowed, which would be 15 years. And if the court makes findings, which findings have to be in writing, that the defendant is not a danger to the community, then the court can reinstate the probation for the VOP. So once we're looking at the findings, what findings does the court have to make for purposes of finding whether the defendant is a violent felony offender of special concern? What we look at is the Florida statute. It guides us 948.06, subsection 8B3, and 948.06C12. So the defendant is a violent felony offender of special concern because the defendant was on felony probation for any offense, which is the fleeing and elude, and the defendant violated his felony probation by committing a qualifying offense. And we look at the list of qualifying offenses, and burglary of a dwelling while armed with a firearm is a qualifying offense. So he qualifies for purposes of a violent felony offender of special concern pursuant to 948.06. He does qualify as a violent felony offender of special concern. And that is all the court needs to find at this time to determine he is in fact a violent felony offender of special concern. Then we will go forward to determine is he a danger to the community or is he not. So at this time the state would ask the court to find that he is in fact a violent felony offender of special concern based upon the fact that he was on probation for a felony and he committed a enumerated offense while on probation.
Your Honor, there is no argument here. The plain reading of the statute, I would agree with the state's analysis. This portion.
Finds he's a violent felony offender of special concern. He committed an armed burglary of a dwelling while on probation. Jury found him guilty.
Okay. All right.
Designated.
Thank you, Your Honor. And the next step is there has to be written findings from the court. I have prepared a Word document with the findings that I'm going to argue, so Your Honor can modify that if you don't find that I have proven anything that's already previously been provided. Do you have a copy of that, Your Honor? It was, okay. Your Honor, the state would ask the court to consider the following when determining whether or not the defendant is a danger to the community. And 948.06, subsection 8E1A, the first thing that the court can consider is the nature and the circumstances of the violation and any offense charge. So the violation, I've already laid the foundation and told the court the facts of the fleeing and looting is pretty egregious at high speed, going through Crestview, running stop signs, running red lights, fleeing, slinging mud on the deputies when they approached his car, and he wasn't stopped until the use of spike strips. He admitted to fleeing. He admitted to having a driver's license that was suspended as the basis. Well, that was one of the reasons he fled. So the court can take that into consideration. And while on felony probation, on August 11th of 2021, the defendant, as the court heard during the 3-day trial, he broke into a stranger's home without permission while wearing all black clothing. During the burglary, the defendant was carrying a loaded, functional firearm with an extended magazine. He also was in possession of a rope and numerous bullets. At the time of the offense, that when he committed the burglary of a dwelling, the defendant was a convicted felon, and the jury also found that. There were 2 occupants inside the dwelling as well when Mr. Gabriel broke into the home. The jury unanimously found the defendant guilty of both burglary of a dwelling and possession of a firearm. And on that same date, the court found the defendant had in fact violated his probation. So that's one of the things the court can consider when determining is the defendant a danger to the community. Another thing the court is to consider is the defendant's present conduct, including his criminal convictions. In addition to the 3 felony offenses pending before the court for sentencing, the defendant does have a criminal history, as the court can see on the score sheet, that includes convictions of 2 felonies, which is included in the pen pack that he had just been released from prison for, and 11 prior misdemeanor convictions. That's also something the court can consider. The court also should consider the offender's amenity to non-incarcerative sanctions based on the history, the conduct during probation. The current violation of probation before the court is the defendant's 3rd violation throughout his criminal career. This will be his 3rd VOP conviction. The defendant committed the new qualifying offenses, and he violated his probation in less than 2 months after being placed on felony supervision, and approximately 1 year and 2 months after being released from prison on separate felony offenses, which clearly, the state will argue, demonstrates to the court that the defendant is absolutely not amenable to non-incarcerative sanctions. The other thing the court can consider is the weight of the evidence against the offender. I think that's pretty clear. The jury found beyond a reasonable doubt that the defendant did commit these new qualifying offenses, and the court found beyond a preponderance of the evidence that the defendant did violate his probation. So the weight of the evidence against the offender is very strong, and the court looks at that as well when determining is he a danger to the community or is he not. Lastly, any other facts the court considers to be relevant when determining is he a danger, is he not. And again, the danger is important because the statute indicates if the court finds that he is a danger to the community, the court shall revoke probation and shall sentence up to the statutory maximum. But because he's a violent felony of special concern, and because counts 1 and 2 include firearms under the 1020 life statute, the court shall impose any term of imprisonment for this subsection consecutively to any other term of imprisonment imposed for another felony offense. So if the court does find the defendant is in fact a danger to the community, the court shall sentence, revoke and terminate probation, shall sentence the defendant up to 15 years in prison, and it shall run consecutively to the other 1020 lives. So because he's also a prison releasee reoffender, that's something else the court can take into consideration when determining if the defendant is a danger to the community or not. Your Honor, because The finding has to be in writing. I know you have a copy, so you can make those findings or adjust as they own, but I'm asking the court to make a finding that the defendant is a danger to the community at this time.
Your Honor, I would argue that the defendant is not a danger to the community, and I would point the court to his score sheet to reflect that. He was on probation and for fleeing or attempting to elude. That is not a violent offense. His other prior felony convictions and misdemeanor convictions were of no violent nature. The case in which he was convicted of the armed burglary to a dwelling, no violence was alleged to have occurred. Although it wasn't a determining factor and the juries came back guilty, there was evidence in trial that he surrendered immediately once inside the dwelling and pursued no violence against the victim in this case. There's no history of violence that can be proven or that can be shown to the court by any of his prior criminal convictions, and for that reason, I would ask the court not to make a determination that he is, or written findings that he does not pose a danger to the community, and ask that the imprisonment be run concurrent and not consecutive.
Well, the court finds that in considering everything that I've read, he is a danger to the community. He's designated a prior prison release reoffender, and he was in danger to the community, when he was fleeing at a high speed, endangered the lives of those officers and possibly who knows how many citizens in Crestview. He has repeatedly violated probation. He broke into the victim's house at night with black clothes and a rope and a semi-automatic firearm, an extended magazine, if I recall, and I think terrified the homeowner, who I think Mr. Gabriel is lucky the homeowner didn't shoot him. I'm really at a loss as to why Mr. Gabriel has taken this path, because Mr. Gabriel was always very respectful in court. He was very respectful in trial. He's seemed like he's been respectful to the attorneys. Why, when he's out, he does all these violent things and has put himself into this situation, and citizens of this community have got to know that the courts and the law enforcement, they're going to do what we can to protect the community if certain people act in a manner that puts the community in danger. So the court finds that he is a danger to the community.
Thank you, Your Honor. And I would just ask that the court submit the written findings.
Well, the court will submit the written findings of fact contemporaneously with the sentence.
Thank you, Your Honor. As for the state's sentencing recommendation for the violation of probation case, I would ask the court at this time to dismiss the violations listed under Roman numeral 1 through 5 in the VOP addendum violation report, as the state did not present evidence as to those specific violations at the VOP hearing. So just 1 through 5, we're asking for a dismissal, Your Honor.
Court will dismiss 1 through 5.
Thank you. And the defendant was found guilty by this court as to violations Roman numeral 6 through 10 in the addendum violation report. And based on that, as well as the defendant being classified as a violent felony offender of special concern, as well as a danger to the community, the state's recommendation is an adjudication of guilt. He will be sentenced as a violent felony offender of special concern, 15 years in the Department of Corrections, consecutive to count 1 in 21 CF 2022. There's also a cost of prosecution, and all monies state's requesting monies just be sent to collection and to revoke and terminate that probation. So in short, Your Honor, the state's asking for a mandatory minimum 10 years concurrent with mandatory minimum life in count 1, also to forfeit any firearms or ammunition that's in evidence. And I'm asking count 1 to be served first. The life sentence should be served first. State's recommending count 2 to be 15 years DOC with a 3-year minimum mandatory to be served concurrent to count 1. And then for the VOP, revoke and terminate, 15 years, the Department of Corrections, consecutive to count 1 in 21 CF 2022.
Your Honor, pursuant to the court's findings today regarding the PRR designation and the violent felony offender special concern recommendation, there's really no other sentence that the defense can argue or request.
I believe these are mandatory sentences, aren't they?
That's correct.
All right, Mr. Gabriel, the count 1, 21 CF 2022. Court adjudicates you guilty, sends you to a minimum mandatory life, Department of Corrections, as a prison release reoffender pursuant to 775.082. Designation and 10 years minimum mandatory in Florida Department of Corrections pursuant to 775.07(2), which is the 1020 life statute. Both minimum mandatory life sentence and a 10-year minimum mandatory sentence for count 1 are to run concurrent. Forfeit the firearm and ammunition and evidence, and sentence to count 1 is to be served first. In 21 CF 2022, count 2, possession of firearm by a convicted felon. And the first count 1 was a burglary of a dwelling while armed with a firearm. Count 2, as I recall, is possession of firearm by a convicted felon. Court adjudicates you guilty, sends you 15 years Department of Corrections with a 3-year minimum mandatory pursuant to a 1020 life statute. Entire sentence for count 2 is to be served concurrent to count 1. 415 court costs, $100 cost of prosecution. All money should be sent to collections. In 20 CF 2880, the violation of probation, the court found you violated probation. In counts 6 through 10, court is going to sign and file a finding of violent felony offender of special concern contemporaneous with this sentence, and has found that you're a danger to the community, and court adjudges you guilty on that count, sentences you as a violent felony offender of special concerns, 15 years Department of Corrections consecutive to count 1 and 21 CF 2022, $100 cost of prosecution and court costs. All money is to be sent to collections. Court's going to revoke and terminate probation. And in 2021 CF 1861, driving license suspended or revoked, state's dismissing.
They will announce a null pros in that case.
Mr. Gabriel, I don't know why you chose to do this. In fact, while the court was thinking throughout the trial, this man is so respectful. Why you broke into the victim's home? He had every right to probably shoot you and had mercy on you and didn't shoot you, but he was terrified, and justifiably so. Why you would do this? You broke in dressed in black with a rope and a firearm in the middle of the night, the man's sleeping, his minor daughter is there, and all these other things that I don't understand why you did it. And the court has no choice but to sentence you the way it did. So I don't know what else to say, but that's the sentence of the court.
Yes, Your Honor, and if Your Honor could remind the defendant the standard right to
Yes.
appeal within 30 days.
You have
and
a right to appeal within 30 days. File your notice of appeal. Ms. Flowers will help you with that. And I guess they have appellate attorneys.
He has the right to have a public defender appointed if he chooses to appeal.
Yes, you have
30
right
days.
to the appeal at no cost to yourself.
And that is the judgment and sentence, the right to appeal the judgment and
That
sentence
is
specifically.
right. The right to appeal the judgment and sentence, file your notice of appeal within 30 days. Thank you. Court is filing its written finding of facts, violent felony offender, special concern, contemporaneous with the sentence. Court is filing a score sheet. And the court is filing the pre-sentence investigation.
And I will follow up with a written null pros for the driving while license
Yes.
suspended case.
Okay, is there anything further on,
No, Your Honor.
all right, thank y'all. Thank you.
I have a question on a case that was called earlier. Jamie Bernard, did we issue a KPS?
No, he filed,
Oh.
a motion to continue, and Judge Clay not Judge Clay.
Oh, that's fine, I didn't. Very well,
Is that
thank
a
you.
man, Jamie McDonald?
No, it's a man.
Okay.
Yeah.
And now, I think we have something with Mr. Roca, correct?
Yes, Your Honor. If we can recall Mr. Roca, and for the record, Brad Stewart on behalf of Anthony Roca. Judge, this is 21 CF 3271. If I may pause for a moment while Mr. Roca signs the previously reviewed written plea agreement. Everything's the same, no additions. Do you have the score sheet? I did check it, by the way. It's accurate, okay? Your Honor, at this time, Mr. Roca is prepared to tender a plea of no contest. Judge, this was a 5-count information that was filed on Mr. Roca. The substance of the agreement is he will enter a no contest plea. Counts 1 and 4 shall be dismissed. Count 2 was previously dismissed based on double jeopardy grounds, Judge. As it relates to count 3, he shall be adjudicated guilty, placed in the Department of Corrections for a period of 10 years with credit for all time served. That's going to be concurrent, Judge, with count 5. It'll be followed by 7 years of probation, 515 court costs, no contact with the victim substance abuse evaluation and treatment, betters intervention program while on probation. Reserve restitution for 180 days. As it relates to count 5, Judge, possession of firearm by convicted felon, he'll be adjudicated. That will be the 3 years in Department of Corrections as a minimum mandatory, concurrent with count 3. I'm going to ask the court to waive cost supervision and recommend to house in a local facility, Judge. I do have a score sheet as well. May I approach?
All right, this is 21 CF 3271, State of Florida versus Anthony William Roca. Mr. Roca, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes. Yes.
Okay. You want to enter a no contest plea to the charge of is it the aggravated battery?
Correct, Judge.
A first-degree felony, correct?
Yes, sir. And count 5, possession
And
of
count
firearm.
5, possession of firearm by a convicted felon, a second-degree felony. So you want to enter a no contest plea to those charges, and count 1 and 4 are going to be dismissed by the state, and count 2 has been previously dismissed, correct?
Yes, Judge.
So you understand that, Mr. Roca?
Yes, sir.
Did you read and sign this plea and sentencing agreement form? Did you read and sign this plea and sentencing agreement form?
No, I don't think I did.
Did you,
Yeah, you read it to me? Yeah.
did you sign it?
Yes, sir.
Okay.
All right, I see your signature, Anthony William Roca, I believe, dated today. Is this your signature on this plea and sentencing agreement form? Pardon? It is? Are you aware of the rights you're waiving by entering this plea? Mr. Roca?
What right am I waiving?
Your rights to trial.
Are you aware of the rights you're waiving? They're all listed in this plea and sentencing agreement form. Are you aware of the rights you're waiving? Your right to trial, your right to plead not guilty, your right to be represented by a lawyer, right to compel any witnesses to testify for you on your behalf, the right to remain silent, the right to cross-examine witnesses the state puts on, the right to make the state prove its case beyond and to the exclusion of every reasonable doubt. Those rights, do you understand you're waiving those rights?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Stewart has done for you on your case? Are you happy with the work Mr. Stewart's done for you on your case?
Forgive me, Honor, I'm sorry.
Okay.
I'm a little emotional right now, so
I understand. He has apparently gotten counts 1 and 4 dismissed and count 2 dismissed out of 5 counts. One count that was dismissed was a life felony, a felony punishable by life in prison. Another count that he got dismissed was apparently a felony battery. Another count that he got dismissed was aggravated assault, a third-degree felony. So those are the things he's done, so that I can see. Are you happy with the work Mr. Stewart's done for you on your case?
yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts the plea. On count 3, aggravated battery, which has a 30-year potential sentence, you're judged guilty, sentenced to 10 years Department of Corrections with credit for time served, concurrent with count 5, followed by 7 years probation, 515 court costs, no contact with the victim, have a substance abuse evaluation with treatment and batter's intervention program while on probation. The court will reserve on restitution for 180 days. On count 5, you are judged guilty, sentenced to 3 years Department of Corrections as a minimum mandatory, concurrent with count 3 with credit for time served. And the court is going to waive cost of supervision and recommend housing in local facility, which I have absolutely no control over with the Department of Corrections. But anything further on that?
No, Your Honor.
Okay. Thank you.
I don't know from probation standpoint if Mr. Roca has previously been convicted of a 6 offense, but I believe he was on GPS monitoring. Ask Mr. Roca that.
I don't know about the monitor, but he was convicted of a sex offense.
Wasn't on a monitor. No, sir.
He may
I had
be-
Mr. Roberta Arthur. I wasn't on a monitor.
He may be subject to GPS monitoring now.
And I've advised Mr. Roca of that when he's placed on probation, the statutory scheme may require him to wear a GPS monitor. If that is the case, Judge, I would request that the court declare that $1 a day, if that is required.
All right, and the court, that's part of the 7 years probation followed, that all of the statutory requirements regarding that that is applicable with that count are imposed by the court.
And Judge would assess that at $1 a day, the
Yes.
GPS?
Yes.
Very good. Madam Clerk, are we good?
Anything further?
No, Your Honor, not from defense.
All right, so good luck to you, and get this behind you.
Yes, sir.
Your Honor, that's all I have. May I be excused?
Yes, so that takes care of, that, I guess that takes care of all our trials.
Yes,
That-
Judge.
It does, okay.
Good job.
Let me see y'all up here real quick.
The answer might be that. Your Honor, if I may approach with this,
Yeah.
is